Yes, good evening to everybody. Welcome to my maiden class of the law of tort today. And it is
Good
me,
evening, sir.
Dr. Mohammed Saheb Hussain. Yes, good evening to everybody. And that I'm going to deal the today topic, which I already made it on the post. I posted it. Today topic is nature and definition of the law of tort. So anyone can unmute and read what I put on the screen so that I could know that you are with me and I am with you. Both are traveling the same boat to reach the destination. Yes, anyone can. Aparna Reddy, could you unmute and read what I posted on the screen? Aparna Reddy, could you unmute and read what I posted on the screen? I don't know whether Aparna Reddy could know it, mute it, unmute it. At least now anyone can unmute and read what I posted on the screen.
Sir, I can see law of torts. Tort law. Professor Doctor. I can see your name and tort law.
You could see it very clearly.
Yes, sir. Yes, sir.
Okay, now let us, let us, without wasting the time, that I would like to go to the today class, online class, nature. Read, what is that? Nature.
Nature and definition of tort.
So this I put it there is a one sign I put it. What can you? Anybody will tell what is the sign? If you don't know, you can say pass on. I will give the answer. If you know that the sign here, I highlighted it. See here the sign that the equivalent is and. The equivalent English equivalent is and, but the sign name is, it's a specific name for the sign. Anyone? If you don't know it, say pass on so that I could give the answer to you. Anyone unmute and give me the answer? Say, sir, pass on. You tell pass on, I will give the answer.
Sir, identity.
Yes, sir?
Identity.
No.
Gurtu Telugu.
There is a specific name is there. That's the reason I intentionally put it over there. See, whenever such a signs and symbol should not be used in the title or subtitle. You should have to write and in this way. This is the style of writing. In the heading or side heading or subheading, you are not supposed to use any sign and symbol. You should not use the contractions. You should not use the abbreviation. You should not use any acronyms. Of course, I will tell you that what is acronym, what is the contraction, what is the sign and symbol. But at the present, I made the symbol sign over there. The sign is, here I am giving you the explanation. See, the explanation which I am giving you is, can you read anyone? This is, anyone can unmute and read.
Yeah, that is the plus symbol is addition,
Yes,
minus
this is the
symbol
plus.
is subtraction,
Yes, sir. Very good.
and the into symbol is multiplication, and the question mark, which is in the quotation of divided by, is called sign of division, and equivalent is and
This
symbol.
is here. This symbol, this sign which is represented here. See here the sign I made it. This is a plus. That means addition. Okay, very good. This is a sign minus. This is subtraction equivalent. This is into. Its equivalent is multiplication. And what about this division sign? What do you call here in this question mark? What do you say? See, here also I put the
Divided,
question. Yes.
divided.
That is already put over there as the equivalent. I already put over there division, but it is having a separate name. Here it is having a separate name. That's why I tell my student, don't miss my class. If you miss my class, you will miss many things. It is called obelus.
Obelus.
And yes, and this is called ampersand. One is obelus, another is
Ampersand, correct.
ampersand. See here I have given the explanation. Ovales in mathematics. An ovales is a symbol consisting of a line which with the dots above and below, like the symbol which is made over here. And it is also known as the division sign. It could be mean, ratio, or division, or numerator and denominator. And these all tweak in the meaning of the symbol. In the same manner, what does the ampersand mean? See, ampersand here, and this is a ampersand, equivalent is and. The symbol is represented by this sign, and the ampersand is the full form of it, is a visual representation of the phrase and or per se. So now this is ampersand and this is obelus. Is it clear? Say yes.
Yes, it is absolutely
Yes.
clear.
So that's the reason. Don't miss my class. You miss many things in addition to that. Here, nature and the definition of the tort. Then let us see the introduction. The term, double quotation begin here. Tort has been derived from the Latin term tortum. So it is the Latin term is tortum, T-O-R-T-U-M. Whenever the Latin term is written over there, we should not write in this fashion, but we should write in. Tell me. I made it, I changed it now. We should write in. If you don't know, you tell me. Pass on, I will give you the answer.
In the bold,
Italic.
Italics, very good. I appreciate it. That is the italics. I changed it. Whenever the Latin word is used over there, please try to keep in italics. Sir, how do we keep the italics when you are writing? Can you write in the slant? Not necessary. If you could write it in the slant, you can write it. If not, you can just underline it. Is enough. It is a amount to italics, which means to twist. The tata means twist. Another meaning is crooked. Twisted, crooked, unlawful, or a wrongful act, rather an act that is a straight or lawful. Which is a straight act or lawful act, it is not a tortum. Which is crooked, twisted, unlawful, not straight, then we can say it's a tortum. So tort has derived from the Latin terminology tortum. Thus tort may be defined as a civil wrong. If the definition, if you want to see, is a tort, generally we will say it's a civil wrong. When you say civil wrong, then automatically there is a word comes, what is the criminal wrong? Yes? When you say civil wrong, what is the criminal wrong? Anyone? Hurry up. If you don't know, you say pass on. Don't waste the time.
pass on, sir. Pass on.
Yes, even beating, murder, and attacking, threatening, this is all criminal wrong. But some wrongs are both civil and as well as the criminal wrongs. Like defamation, it's both civil wrong as well as the criminal wrong. Nuisance, both as a civil wrong as a criminal wrong. Okay, later in the other chapters, when you go further, you will understand the difference very much. So here the tort is a civil wrong, which is responsible for an action, for unliquidated damages. Can anybody say what is unliquidated damages? If you know it, you tell me. If you don't know it, you say pass on. Hurry up. Anyone, I said. But not in chorus.
It's not amountable, sir.
Yes, Kiran?
Which is not amountable. ఎక్కడైతే
Which
మనం
is not ascertained, which is not predetermined, which is not agreed in the advance. So that is the, now I would like to stop the video because there is a bifurcation should be there, because much load would be there on the Wi-Fi. Okay, it is the unliquidated damages, and which is rather than a mere breach of a contract. It is not a contract, breach of a contract, nor a breach of a trust, which civil wrong, that is a tort. The law of tort is an uncodified law, but is mentioned under the section 2. What about this? Under section 2, read.
Subsection M.
No.
clause
Professor Hussain students will not. They will read in a perfect like a Professor Hussain. Anyone?
section 2 clause M.
I appreciate. I will tell you the difference between a class and a section, subsection also in further classes. Don't worry. Whenever the small alphabetic is written over there in the parenthesis, this is called, sir, I don't know, sir. What about this one? This one here I am making. Is which type of the bracket it is? What type of the
Parenthesis.
bracket it is?
Parenthesis.
It is a, Professor Hussain says the parenthesis. But what is the bracket name? I will show you here. See, here I used this bracket. Did you see this bracket, which I am highlighted here? Quick. If you know it, you tell me. If you don't know it, you say pass on. What is the name of the bracket? Yes, Professor Hussain, students will say the parenthesis. Parentheses. But in general, what do you name the bracket name?
Angle bracket.
No. It is a curve bracket. No. It is a circular bracket. Or another name also there. Or we can say parenthesis also. Professor Hussain students say parenthesis. But it is having the name. It is a round bracket. And whatever this one, this bracket. Hurry up. This is round bracket or circular bracket. Either you can say round bracket or circular bracket. But Professor Hussain students will not say either the round bracket or the circular bracket. They will say parenthesis. What about this one? Hurry up, quick. If you know it, you tell me. If you don't know it, you pass on. You say pass on.
Pass on, sir.
Yes. Why you are taking so much time? Sir, we are searching the smartphone, sir. You cannot search it in the limited time in the smartphone. This is not the point. It is called square bracket. What about this one? Whatever the bracket it is?
Curly bracket.
Curl bracket, or we can say curve bracket also. Both the way you can say. Sir, sometimes say flower bracket, but more appropriately curl bracket. C-U-R-L, curl bracket. What about this bracket? If you know it, you tell me. If you don't know it, say pass on.
Angle bracket.
Repeat.
Angle bracket.
Angle bracket. I appreciate. Or that is the angular bracket or angular bracket. So these are the bracket which because I got the chance to explain you the bracket here, I got it. Whenever I ask it, you should have to say that. So here the section 2, clause M of the Limitation Act of 1963. The Limitation Act. What is another name for the Limitation Act? Sir, we don't know, sir. Law of limitation is there for everything. Okay, now let us come to the definition. After the definition, what is this here? What is the sign over there after the definition? If you know it, you tell me. If you don't know it, you say pass on. I will give the answer.
Semicolon.
No. I will show you what is the semicolon. See, here I will show you what is the semicolon. This is the semicolon. This is the semicolon. Can I highlight it or could you see it? This is semicolon. But here it is like this. What do you call this one?
Colon.
Colon. I appreciate it. Another clapping for the colon. Yes. So my purpose of is never read blindly. That's my point. Never read blindly. So in the quotation that I would like to read it, the double inverted comma quotation, I quote, this is the style of reading. Professor Hussain students will read in this style. How? I quote, C-U-O-Q-U-O-T, I quote, tort as a civil wrong for which the remedy is common law action for unliquidated damages and which is not exclusively a breach of contract or the breach of trust or other merely equitable obligations, I unquote, according to Salman. Next time when I asked you to read, you have to read in this fashion. Yes, now you read it. Any one of the unmute and read this one. I will give the explanation later. Hurry up. Hurry up.
I quoted, tortious liability arises from the breach of a duty primarily fixed by law. This duty is towards persons generally, and its breach is reprehensible by an action for unliquidated damages. Unquoted.
I unquote.
Okay.
I quote in the beginning. In the ending,
Yes.
I unquote. Spelling I space unquote, UNQUOTE. I unquote according to the Winfield. Now let us see the definition of the Salmon. So, tort is a civil wrong. Yes, it is not a criminal wrong. Good. But some torts are civil wrong and both criminal wrong. Later we will study it in further classes. But time being, it is a civil wrong for which the remedy, the solution, what are the remedy available is common law action. Then what is the common law action? Means common law means that law where a person or a prudent man supposed to follow it, that is said to be the common law. I repeat, common law means that law where a prudent man supposed to follow is said to be the common law. So common law action for unliquidated damages, I told you just before. Liquidated damages in the contract, which is ascertained, predetermined, known before the breach of contract. But here, unliquidated damage, it will be ascertained only after the accident. For instance, you take the motor vehicle accident. If the motor vehicle accident, you can claim both the way. One is the police case, another is the compensation case. So, when you compensation case, you are filing in the motor vehicle, under the Motor Vehicle Act, then you approach to the Motor Vehicle Tribunal. The tribunal will be there which will undertake these cases. And there, the damages will not be ascertained in the beginning. I will make an accident, you give me this much amount. No. Could you make such a contract? Could you make such a contract? I will make an accident with you and I will give you this much amount. Could you do such a thing?
No.
No. So it is when an unexpected event happened over there, an accident occurred over there, then they will make the start of it because there is a assessment of the damages are there. There we will read it. Don't worry now. So the assessment will be made. The finally amount will be fixed. Of course, a lawyer will make, and an advocate make the different slots would be there. Then he will make, okay, this much amount should be paid as a compensation for the injury. It will be ascertained only later. That is called unliquidated damages compensation in the law of tort, but liquidated compensation or damages in the contract. Whenever the breach of the contract would be there, at the time the party agree to a certain amount as a penalty, certain amount as a punishment, certain amount as a fine. So predetermined by the two parties are liquidated damages, unascertained are said to be the unliquidated damages. But in the contract, liquidated damages, in the law of tort, unliquidated damages should be there. Okay, that is the Solomon definition. Then when I refer to the Winfield definition is tortious liability. How many liabilities are there? Civil liability, criminal liability, group liability, mass liability. Are you following me?
Yes, yes.
Tortious liability means civil liability. Tortious liability arises, it comes out. Can you tell me why that arises is what is used over here? Why not arise? Anyone? Why SES is written over there? Why not SE?
Because
Anyone?
arises is belongs to the simple present. The universal statements we used to write in the simple present, right?
I appreciate. Clap. Whenever the subject is a singular, then the auxiliary verb should be in the singular. That rule is called, sir, is it a grammar class or is it a law of tort class? If you know it, you tell me. If you don't know it, I will give the answer.
Simple
Say, class
present,
one.
sir. He, she, it. Yes.
The rule is called,
Simple
you say
present.
pass on, I will give the answer.
Simple present.
See, I am not asking
He,
that.
she, it. Yes is coming, sir.
I am giving the question is, it is the rule is called subject agreement rule. The rule is called subject agreement rule. Whenever the subject is singular, the verb should be the singular. Whenever the subject is a plural, the verb should be the plural. That is called, the rule is called
Subject agreement rule.
subject agreement. There are 24 subject agreements are there. You need not worry about that one now. There are 24 subject agreements are there where we will follow these rules. So the tortious liability arises because it is a plural singular form from the breach of a duty breach of a duty, here they say duty. When you say duty, there is a right also. Are you following me? Breach of a duty means somebody is having a right. So primarily fixed by law, a law should fix such as a duty. Who will fix the duty? A law will fix such a duty, either in the form of legislation, or in the form of the custom, or in the form of a usage, or in the form of a prudent man supposed to do it. This duty is towards a person. It is towards the person. Means there should be a particular person. Here person may be a boy is a person, a girl is a person, a old age man is a person, a senile is a person. Who is a senile? S-E-N-I-L-E, senile. A person who is more than very old, roughly 70 to 80 years old, not having that much mental maturity. I don't say maturity is there, but he could not understand certain things at the time because of the old age is concerned. At that time, the person generally, even a foetus, means, you know foetus? F-O-E-T-U-S. If you know it, you tell me. If you don't know, say pass on.
Coitus means unborn baby.
In the mother's womb, conception is made over there. That is called a fetus. The gestation period is 9 months. Okay, in the uterus. The person generally, even a fetus also a person generally, and its breach is repressible by an action. It will be redressed by an action for unliquidated damages. Again, they say unliquidated damages. So this is the definition which is given by the Winfield. So now the tort means it is a civil wrong. Very good. It is other than the breach of a contract or breach of a trust or breach of a quasi-contract. That breach is primarily fixed by law or by the custom or by the usage, or a prudent man supposed to do it. And this duty is towards a person. You should do it towards a particular person. Generally I said, it is a breach is, and is a breach is a repressible, means redressable, recoverable, and redressed by an action. What action? By some action for unliquidated damages, means sum of the amount. The primary aim of the law of tort is to get the compensation, damages. The primary aim of the tort is to get the damages, means compensation, in the form of
Liquidity, cash.
money, cash, hard cash, money. But not in money, we can say panacea. Not the punishment, not the incarceration. That is called putting behind the bar. Bar means not that bar, whiskey bar. Bar means bar and bench, here the prison, we can say. Time being, the context is. Okay, this is the meaning there. We can take it liquidated damages and unliquidated damages. Sir, what is the difference between the damages and compensation, sir? Sir, don't ask so much questions, sir, because today is the first day, no, sir. I told you that my class should be a participatory class. That's my intention. Not a one-way traffic. There should be two-way also. I should get the response from your side so that I could know that you are hearing me. Is it or not? Can anybody will give me the distinction between damages and compensation? Yes. If you know it, you can try. Don't matter. There is no minus marks, please. Of course, if you give the good answer, I will clap it. I will say very good.
Compensator for the damages, right? Whatever the loss we got it. So according to the loss, there should be a value calculated and they will pay in the form of cash.
But generally we use it both in synonym way. Because damages, compensation, we use the synonymous way. But when you say that, a compensation is a broader terminology. Compensation is a broader terminology. Damages, when you say the damages, only one should have to speak. Najib, you want to speak, you can speak. Najib, you want to speak?
Compensation is the award in a lawsuit awarded to plaintiff, and damages are the funds provided for the loss done by the defendant to the plaintiff. I think
Okay. I appreciate. You now you mute it. Najib, you mute it now. Yes. See, the compensation may be any form. But when you say the damages specifically, there are nominal damages, general damages, special damages, contemptuous damages, damages in terrorem, and exemplary damages, aggravated damages. But when you say compensation in the form of generally the money, but how the time, the variety is in the damages. So compensation will be paid in through the form of the damages, but sometimes compensation may be injunction. Are you following me? Injunction. You know the
Yes, sir.
injunction. Are you following
Yeah.
me?
Yes, sir.
Say yes. Okay. So here later, yes, mute. When you want to ask the question at the time, you unmute it. When I don't ask the question, you have to mute it. Okay, otherwise I will get in the resound. And your house sound also I could hear you, what you are speaking. Okay, this is the way that we can make it out. People are joining very late also. I have to admit, because my diversion would be there. Okay, now let us see that nature of your tort. Sir, here I say nature of tort, but in other place, I don't say nature of the tort. I say anatomy of tort. Professor Hussain, students say anatomy of tort. Sir, even I never saw this word. No, you see, the anatomy of law of tort written by English author. The English author name is there, anatomy by the law of tort. Anatomy of law of tort. So let us see the nature of tort. Then a tort is a civil wrong, as I told you, and thus can be differentiated from the various other forms of like crime. Can you give an example for the crime? Najib, you try to use your earphone. That will be quite good. Otherwise, I am getting the resound.
Is nothing but a
Okay,
murder, right?
Satya human
Murder
rights.
is also a
Okay.
crime.
Okay. Right. Okay, now you unmute. I got the point. Here, a crime which is defined in the IPC, it is also defined in the General Class Act also. A violation of a particular right within general to the public at a large, if you do it, we say it's a crime. Like example is theft, murder, robbery, dacoity, riots, nuisance. These are all said to be the crimes. Suppose if you smoke in a public place, what do you call it? Yes? Suppose you smoke in a public place, sir, he committed a crime.
Nuisance.
Generally, we don't say crime there. If you spit in a public place, or if you spit on the road, or not in the spit tune, generally we don't say he committed a crime. We will say it is an offense. A modern form of crime is an offense, they use the word. But a heinous crimes, a traditional crimes, then we don't say, sir, he committed the murder offense. Can you say he committed the murder offense? Can we say we committed the murder offense? No. We say he committed a crime of murder, or he murdered. He committed a crime of rape. But when you smoke in the public place, you cannot, don't exactly say the crime, but we will say it's an offense. A modern form, a little form where the punishment is less, where the depth of the gratitude of the offense is very less, we can say offense, but don't say crime. Sir, suppose In the night, in the villages, you might have seen it. Villagers, in the electricity, they will theft it by keeping the two wires on the, one is on the phase, another is on the neutral, and they will use the electricity in the night. In the morning, the hooks, they will remove it. Can you say it is a theft? Is it a stealing? Is it a robbery? Is it a dacoity? Anyone?
That is an offense.
It is an offense, but it is having a specific name. It is having a specific name. Can anyone? If you know it, you tell me. If you don't know it, it is a petty offense. Yes? If you know it, you tell me. If you don't know it, say pass on. I will give the answer. Don't waste the time.
Pass, sir.
Sir, you are checking the smartphone. You cannot get it unless you know the meaning of it. It is called pilferage. Pilferage. Stealing in a little quantity is called pilferage offense. Of course, no doubt it is a theft. No doubt it is a theft. And see, pilferage, for instance, you take the school children, especially primary schools, when the interval time, when the students will come out to buy certain things, by the time, if a sugar loaded cart is going on, I repeat, a sugar loaded bag cart is going on, behind the cart will pick with the forefinger and try to steal the little quantity of the sugar, and they eat it till it passes the premises. No doubt it is a theft, but it is a pilferage. Means stealing in the little quantity to eat the school children. So we can say it is also a small theft, but we can say it is not a crime, it is a small offense. It is called trifling in another sense. But can a Carter will bring an action against the students? Yes? Sir, who is the Carter, sir? Jimmy Carter, sir? Who is the Carter? Who is the Carter? C-A-R-T-E-R, Carter. If you know it, you tell me. If you don't know it, you say person.
Pass on, sir. Sorry.
A person who drives, who moves the cart, bullock cart is called a carter. A person who drives the car is called the
Driver.
driver. But a personal driver is called the personal driver, sir. Chauffeur. Chauffeur, spelling C-H-A-U-F-F-E-U-R, chauffeur. A person who drives or moves the plane is called aeroplane.
Pilot.
A person who moves or drives the ship is called
Captain.
captain. Now I will come to the point. A person who drives the motorbike is called
Rider.
a person who sits behind the seat is called
Co-passenger. Sorry, sir.
Professor Hussain. Students will not give the answer.
Pillion rider, sir. Pillion rider.
I appreciate. Pillion rider. Because I was penalized in the Afzalganj, I was wearing the helmet, but my pillion rider is not wearing the helmet. Then he made the offense of not wearing the pillion rider not wearing the helmet. That was the wording is given. Pillion rider, no helmet. That offense, 100 rupees I paid. So now let us come to the point. The difference between the tort and a crime is as follows. Firstly, tort is an infringement of a private or a civil right. It is a private or a civil right, where the only few people or individual get the loss or injury. So that is a private or civil right, and therefore it is considered to be a wrong against a person to whom the damages has been caused. Means an individual will got the damage over there in the tort. But when the crime, other hand, is a public wrong. It is a public wrong where the people at many will be suffered over there. Suppose if you purchased a new music system and you put the new music system volume 12 in the night 12 o'clock, what is the offense that you committed? Yes. What is the offense that you have committed?
Breach of peace.
Public nuisance. Now the public nuisance is a criminal wrong. When an individual is suffered over there, and that is a private nuisance. When the private nuisance is a civil wrong and a public nuisance is a criminal wrong. Sir, you told me no, sir, tort is a civil. No, sometimes tort is both civil and criminal wrong. Secondly, in tort, the injured party himself bringing an action against the wrongdoer. Here, wrongdoer means who? A person who commits a wrong
Crime.
is called a wrongdoer. Okay. But in another name, synonym for the wrongdoer is
Tortfeasor.
tortfeasor. I appreciate. Mallikarjun, I appreciate. Tortfeasor. Whereas in crime, the wrongdoer is prosecuted by the state. Means a tortfeasor. Here, there is another name also, the wrongdoer in the criminal law. What is that?
Accused.
No, we can say accused because accused cannot be punished unless it is proved.
Victim, sir, victim.
Victim is a person who got injured is called the victim. There is another name also there.
Offender.
Yes?
Offender, sir.
It starts with the P
Offender.
letter. It starts with the P letter. Okay, don't worry. You think it out later, I will tell you. So a wrongdoer, he is prosecuted by the state. And here, the state will move the machinery, not the individual, because it's the public wrong. So, even though the victim, the who suffered, in this case is also an individual. So here, an individual is suffered by an individual. But where the by individual is suffered over there, that may be to you or to anybody. Suppose the theft is happened in your house. No doubt, when individual is suffered, but the theft is a civil wrong? No. It may be today your house, tomorrow another person's house. So it's a criminal wrong. So now you tell me, there is a difference between a house breaking, that called burglary, and theft, dacoity, robbery. Of course, you will come across in sooner or later when you go in the further classes. Okay, let us see that the difference between the tort and the contract is as follows. I gave them only 2 or 3 differences over here. There are some 12 differences or 13 differences, I can make it out. So the difference between a tort and a contract is as follows. Here, nutshell, I am making it. Firstly, the contract is the parties where their free consent undertake to perform certain duties, while in tort, the duties are imposed by the law. So in the contract, the 2 parties will make the terms and conditions. But when the contract, in the tort, there is no third party will be known unless until when there was a breach or a violation or the breach of a duty is there. And it is not fixed by the 2 parties. There is the operation of law is there, imposed by the law is there. A statute would be there, a custom would be there, and that will be followed. If the duties is not followed improperly, it is imposed by law, then it is a tort. But there, in the contract, parties make such a terms and conditions. Suppose in India, you have to follow the traffic rule. Left-hand side, you have to go. But in America, sir, we don't know, sir. We have not seen, sir. Not necessarily
Right
one
side.
should have to go to the America. You could see in the movies also.
Right side, sir.
Right-hand drive is there. When the right-hand drive is there, the steering is at what side? Which side? Steering.
Side, sir.
Left hand side. It is left hand side. Sir, you don't know steering, sir. Yeah, it is the left hand side. Okay. But in the India, the steering would be
Right side.
right side. I don't make the debate here. Which side is the preferable? Later I will tell you which side is the preferable. The secondly, in the contract, the contracting parties owe a duty to each other only. Like we have studied in the law of contract. One of the famous case law is there. A stranger to the contract cannot sue because he is not party to the contract. Can you tell me what is the name of the case law of contract? Anyone? A stranger to the contract cannot sue. Sir, we did not study, sir. You already studied law of contract. Sir, we started, sir. Okay, don't worry. There is a famous case law, is the landmark case law. Dunlop Pneumatic Tire versus Selfridge Company. There you will come back in the law of contract. A third party cannot bring an action against the contract because he is not the party to the contract. But in some places, in tort, even a third party can also file a case because privity of contract. Of course, when you come to read the privity of contract, you will understand a person who is not party to the contract can also file a case under the tort. That is the reason we say a tort is a civil wrong arises independently of the contract, not arising from the contract, no, independently. So now a duty not to commit a tort is owed to person generally and not to any particular individual. A duty to be owed to not a particular person. Nobody should have to beat you. The duty towards one individual or to against the whole world. Yes? The duty is towards only individual or to the whole world, not to beat you. Yes?
Individual.
Individual it is. No person in the world could beat any person. Are you following me? Even you cannot touch another person without his consent. If you touch another person, no, sir, I touched him to draw his attention, sir. But you touch in a slight manner. Suppose in the class is going on and the lecturer, the teacher, the faculty is looking at you and you are busy in sending the SMS. Then from the back, and the teacher is gazing at you. From the back, your friend said, but he touches your back, say, to draw your attention, say, sir is looking at you. So that touching is with the intention to drawing the attention of a student who is in front of you. If that student is a girl student, could you touch her?
No.
Sir, I touched her, I patted her just to draw her attention, sir. You are not supposed to touch, even either boy or a girl. If you want to draw the attention, slowly you can lean and tell, sir is looking at you. Please don't send the SMS. With a low whispering voice you can say, but you are not supposed to touch. If you touch it, there is a violation would be there. The breach of the trespass to person. If you touch it also is the trespass to person. Sir, is it applicable to the wife, sir? That is a different issue. Okay? Also a tort of different form from which a breach of trust, there is a breach of trust is there, breach of quasi contracts are there, contracts are there. These are all different from, tort is a bit different, a unique, a specific. So it is in tort, the damages are unliquidated. I told you what is unliquidated. It is not ascertained in the beginning. It will be ascertained only last by assessment of the damages. How much the damages should be paid. So unliquidated, but in breach of trust, they are liquidated. In breach of trust or in breach of contract, or breach of quasi contracts, if the penalty, the breach would be there for the agreement, then there is a fine or there would be a certain amount as a fine or a default, it will be imposed on you. So that is agreed by both the parties, those who are for the contract. So liquidated as they are ascertainable, it will be determined in the beginning before the breach is made before the beneficiary brings an action against the trustee. Suppose the trustee is against the trustee, a beneficiary would be there. For the trust, they will bring an action in the trust. So the trust is different, quasi contracts are different, contract is different, and crime is different, and tort is different. Is it clear? Is it clear?
Yeah. Yes, sir. Yes,
Okay,
yes.
sir.
I appreciate it. See, only 5 minutes are left. Generally, whenever the maximum members are there, you can take the screenshot. And I believe that participants are 30. Anyone can take the screenshot. Whenever the number is high, then you can either post to my individual or you post in the group also. Doesn't matter, because I want to be transparent how many are there in the class. Okay, I told you already, if you miss my class, you miss many things. How many new words that you learned today? You tell me. Keep your hand on your, keep your hand on your, yes, on your, can you say mind? Can you say brain? Can you say heart? Can you say, yes? Which one is the preferable word? నీ గుండె మీద చేపెట్టుకొని చెప్పురా అంటాము తెలుగులో. Say in English.
Keep your hand on your heart.
Yes. A prudent man, how you will keep the hand? He cannot keep the left hand on his heart.
Yeah.
He will keep only the
Right hand.
right hand over the left side heart. Sir, heart is left side, sir. Sometimes right side, sir. Only few people will be there who's a heart with the right hand side. One Sanjay, that movie is there where that fellow heart is the right hand side. He shot at the left hand side, but he did not die it.
Yeah.
I don't know whether you have seen such a movie or not. Very rare cases, the heart would be the right hand side. Okay, now you have learnt a new things. That's why I tell my students, don't miss. Even you teach less, doesn't matter, but it's tightly go to where?
Heart.
Minds of the student or brains of the student? Which one is the appropriate word? Sir, it is a very difficult to hear you. If I say brain, you will say mind. If I say mind, you will say brain. Which one is the appropriate word here? Directly go into the mind or go into the brain?
Mind and
You say generally mind only, because mind your business, you will say. But if you don't say brain your business, your mind means refers to the concentration on a particular thing is called the, we will say that in that way. Use your brain sometime, you will say. Can you say use your mind?
Sir,
Yes, any question?
use your brain. Yeah,
Satya.
initially you said, right, how to read that two in bracket of small letter of A or M. How to read that?
Brackets, you want to say brackets?
No, initially two inside the bracket, if you write M, how to read that? I said that is subsection. That is
Here I
wrong.
have shown you, no, ampersand. But generally you don't read ampersand, because it is sign is ampersand. When you are reading, you read and only.
Yes.
Don't read ampersand.
Yeah, when the symbol is called, we can say ampersand. But
Yes.
in your PPT,
Yeah.
two inside the bracket, there is a small letter M. How to read that in your PPT?
See, generally you want to say articles. Suppose if I give the PPT, let me say here. In the PPT that you want to make it out, either S or not S, both the way you can make it out. See here, article within parentheses I write S. Now, if it is singular, you read as a singular. If it are many, you read as a articles. But when you represent, you represent in this way sometimes. Depending upon that, you can say article or articles.
Yeah.
But when you show in the pages are different. When you show this P, it is a page, means particular page. It's only one page. It is only one page.